The CPI report, Child Protection in Iowa, brought to you by Vocal, Victims of Child Abuse Laws. You can watch our program on Mediacom Channel 15, Sunday afternoon at 1 o'clock. You can see it again on Wednesday evening at 9:30. You can email us at vocaliowa@mchsi.com or give us a call in Des Moines. My telephone number is area code 515-276-3956, and it's John's number, area code 515-282-2672. With me at the controls is my co-host.
And who are you?
Don Burgmaier, and John Harvey's my co-host.
Okay, John Harvey here. Welcome to the CPI report. CPI, that stands for Child Protection in Iowa. That's the issues that we work around in two different areas. One is to influence public policy as it has to do with child protection issues. And secondly, is a hands-on approach, and that is to help those who are having problems with the Department of Human Services, those who request our assistance, and we're only too happy to work with those individuals who are having difficulties because we know that they can do a lot, parents can do a lot of things on their own in working with their own cases, but it's a good idea if you're involved with the DHS or with the juvenile court to find somebody who has been there before and who can give you a little bit of guidance and instructions. We're not attorneys, so we cannot take your case on and practice before the bar, nor can we prepare items for you. We can show you how to prepare and to lead and to engage in debate with the various organizations, particularly with the Department of Human Services. And there's a right way and a wrong way to deal with people. Even though you feel they're adversaries, there is a way of dealing with them. And part of that arises from the fact that we do have a very strict set of statutes by which they are to be held accountable. Now, they may not do things exactly like they should, but it is up to you to know what the law is and to hold them accountable to what the written law is. There's not supposed to be any secret protocols the way these things are run. Sometimes there are, and if they're secret, of course, you have no way of knowing that they're secret, but you know there's something going on behind the scenes. And but the main thing is there are prescribed statutes, there are administrative rules, and it doesn't take a whole lot of effort to at least get accustomed to knowing what some of those rules are. They have to follow them, you have to follow them. That's called equity, when both of you are reading off the same page, singing off the same hymnal. Well, Don, we've seen a lot of things happening. HSLDA seems to be in the midst of a lot of calamity because they are focused on working with families who homeschool their children. And for some reason, the bureaucrats do not like to see this kind of independence out there in the field. And so while they assist homeschool parents, they're also doing a whole lot in assisting other parents as well by coming up with recommendations, and we've read a lot of those recommendations so far. We'll have a few of those on today's program. We'll also talk a little bit about the upcoming legislative session. I say upcoming because for those that are listening to this program on Sunday, the legislature starts tomorrow. For those that are listening on Wednesday, they've been in session now 3 days. So we're right on top of the legislative session, and there's a lot of things that are going to be going on that have to do with our area of concern, and that is child protection. We'll give you a few hints as to what um, is up for this next session. Awful lot of work and a lot of discussion and so forth, and you need to be a part of that. Well, Don, I saw this scene. It sounds like a play or something going on here, but it says, boy hits head, father qualified to make medical decision, checks his son, and concludes that he's okay. And scene 2 says a busybody neighbor, you probably don't have any of those in your neighborhood, but in this neighborhood there was a busybody neighbor that called the ambulance. And in scene 3, the ambulance shows up at the house, and the paramedics demand that the child be brought to a hospital for further examination. The father refuses. Uh-oh. And the following day comes scene 4. The SWAT team shows up, kidnaps the child for evaluation, and the child is later released. Scene 5, the sheriff confesses that father is a constitutionalist. Uh-oh. Someone who wishes to follow the original intent of the U.S. Constitution. Bad news. And he's been making comments for years. Well, so it is in this Colorado town. Don, can you tell us a little more about the SWAT team story?
This paper starts out calling it a police state. In other words, the state is controlled by the police. SWAT officials invade home, take 11-year-old at gunpoint. SWAT, those are cops that are trained with rifles and different things, sharpshooters. So they invade this home. Cop, steaman boy, goes to the doctor because of fall during horseplay. That's what they called it, children playing around. This was posted January 7th. Nearly a dozen members of a police SWAT team in western Colorado punched a hole in the front door and invaded a family's home with guns drawn. How would you like that to happen to your house? You're just sitting there and all of a sudden your door is busted in and men coming in, you can't even identify them. They may have stockings over their head and carrying guns. Anyway, it goes on. They invaded a family's home with guns drawn, demanding that an 11-year-old boy who had an accidental fall accompany them to the hospital. On the order of Garfield County Magistrate Lane Leonock. So there was a court magistrate that was contacted, and so an order went out for this to happen. The boy's parents and siblings were thrown to the floor at gunpoint, and the parents were handcuffed in the weekend assault. And the boy's father told this reporter it was all because a paramedic was upset. The family preferred to care for their son themselves. This father, he was, it may tell us a little later, but this father was trained, and the article says he had more training than the paramedic, so he understood medical issues. So he made the decision, and his son was all right. He just bumped his head. A lot of kids bump their heads. Someone, apparently, the unidentified paramedic, called police, the sheriff's office and social services, that's DHS out there. eventually providing the judge with a report that generated the magistrate's court order to the sheriff's office for the SWAT team assault on the family's home in a mobile home development outside of Glenwood Springs. The father, Tom, told the reporter. The reporter called and emailed Garfield County Social Services, but those contacts were not returned by that DHS office. And the judge, who earlier served as a water court clerk, referee, also was not available. He must have been good enough carrying water that they moved him up to magistrate. Sheriff Lou Valerio, however, did call back and told the reporter he ordered his officers to do exactly what the magistrate demanded. I was given a court order by the magistrate to seize the child and arrange for medical evaluation, and that's what we did. According to friends of the family, the father, who has 10 children, including 6 still at home and served with paramedics in Vietnam, was monitoring his son's condition himself. The paramedic and magistrate, however, ruled that that wasn't adequate and dispatched the officers to take the child, John, that's his name, to a hospital where a doctor evaluated him and released him immediately. The accident happened during horseplay, the father told the reporter. John was grabbing the door handle of a car as his sister was starting to drive away slowly. He slipped, fell to the ground, and hit his head, the father said. He immediately carried his son into their home several doors away. So here's a father who was keeping close eye on his children and actually saw it happen and immediately checked into the seriousness of the bump. So the article goes on. It says John was able to recite Bible verses and correctly spell words as his father and mother, Tina, requested. When there's a person you think has a stroke or different things such as this here, you ask them questions, and if they can answer it clearly, you know that the mind is okay after an accident like this, or at least at that point in time. There were no broken bones, no dilated eyes, or any other noticeable problems. The family, whose members live by faith and homeschool, decided not to call an ambulance, but a neighbor did call a West Care ambulance, and paramedics responded to the home asking to see and evaluate the boy. Now, this doesn't have anything to do with the judge here. It's a neighbor that saw the boy fall down, I guess. I assume she's never seen another boy fall down. And so she takes it on her own to call an ambulance. The paramedics were allowed to see the boy. In other words, the parents allowed the paramedics to see the boy, and found no significant impairment, but wanted to take him to the hospital for an evaluation anyway. Well, that's their job. They get paid for it. Everybody gets paid for things like that. Fearing the hospital's bills, the family refused to allow that. This apparently did not go over well with one of the paramedics, and they started getting aggravated at Tom for not letting, that's the father, for not letting them have their way. The paramedics were not at all respectful of the father's decision, nor did they act in a manner we would expect from professional paramedics. So the ambulance crew, who also could not be reached by the reporter, called police, only to be told the decision was up to the family. The paramedics then told the sheriff's office, and officers responded to the home and were told everyone was being cared for. Then the next day, Friday, social services workers appeared at the door and demanded to talk with John in private. That's the boy. They took him off to the demanded to take him off to the side so that there wouldn't be any influence or protection from the parents. They were so persistent, the father ended up having to get John out of the bathtub he was just soaking in to bring him to the front porch where the social workers could see him, the family reported. Then, now I can just guess, at that point the social workers, after seeing the boy standing there dripping wet and looking okay, that they must have left the house at that point in time. Because I think the Homeschooling Association recommends that. Don't let the social worker come into the home. Then, following an afternoon shopping trip to town, the family settled in for the evening. In other words, they were doing what normal families do in the evening, only to be shocked with the SWAT team attack. The sheriff said the decision to use SWAT team force was justified because the father was a self-proclaimed constitutionalist. That's interesting, John. They teach us Constitution in school, grade school, high school, and I assume college. What's wrong with learning about Constitution? Anyway, however, the sheriff declined to provide a single instance of the father's illegal behavior. He hadn't broken any laws. And the sheriff said, I can't tell you specifically anything. He was refusing to provide medical care. The father refused to take his child to the doctor. However, the sheriff said if his own children were involved in an at-home accident, he would want to be the one to make decisions on their health care as did the father. Interesting comment from the sheriff. He'd have done the same thing as this father was accused of. I guess if that was one of my children, I would make that decision, the sheriff said. But he said the father was rude and confrontational when the paramedics arrived and entered into his home without his permission. Well, I wonder how the sheriff knew that. The sheriff wasn't even there to see what happened. The sheriff also admitted that the injury to the child had been at least 24 hours earlier because the fall apparently happened Thursday afternoon and the SWAT attack happened late Friday evening. Wow, they move fast, don't they? Over a day goes by. Officials with the Homeschool Legal Defense Association reported they were looking into the case because of requests from family members who are members of the organization. While people can debate whether or not the father should have brought his son to the ER, it seems like this was not the kind of emergency that warrants this kind of outrageous conduct by government officials, stated one of the homeschooling spokesmen. The father said when John was evaluated by the physician, they didn't find anything wrong with him. In other words, the hospital, the doctor didn't find anything wrong with him. So that's why they just sent the boy home. He said the paramedics never should have entered his home, but they followed his wife in the front door when she came in. In other words, they just pushed right on through. And that's illegal. You have a right to tell people to stay on the outside of that door, and if they come barging right on in, they're breaking laws. The father said the SWAT team punched a hole in his door with a ramrod. and the first officer in the home pointed a gun right in the face of the father's 20-year-old daughter. Imagine that 20-year-old girl was scared out of her wits, half to death. I don't know where social workers ever got started or where they got their authority, the father said, but I want to know why. We have something in this country that violates our rights, that takes a parental right away. And I agree with that statement. He said he saw a multitude of injuries in Vietnam. That's where he got his medical training through the government when he went to help the battle in Vietnam. I guess you'd call it a battle. That's where the father was. And while he recognized that his son needed to be watched, he wasn't willing to turn his child over to the paramedics. With 10 children, most of them older than John, it's not as if he hadn't seen a bruise or two either. Now I'm hunting for lawyers that will take the case. I'm going to sue everybody whose name was on that page, right down to the judge. Mike Donnelly, a lawyer with the HSLDA, told the reporter of this article, the case had a set of circumstances that could be problematic for authorities. In Doe versus Heck, the 7th Circuit Court of Appeals held that parents have a fundamental right to familial relations, including a liberty interest in the care, custody, and control of their children, he said. He also said many social service agencies apply a one-size-fits-all approach to cases regardless of circumstances. John?
Well, I hope our viewers don't dismiss easily that case in Colorado simply because it's not in Des Moines. But I can tell you that a homeschool family in Des Moines, has been hit by the same thing. Not the SWAT team. They probably couldn't get around to scheduling a SWAT event anyhow on a timely basis. But here's a family that where there was an accusation that a parent actually spanked a child. And parents were told that they could no longer spank the child. The child was taken by the DHS for a medical evaluation of bruises. Well, sorry about that. I think the authorities in the state of Colorado have stepped over the line. I think the authorities of the state of Iowa have stepped over the line. I don't know where they get this authority. A lot of it is an assumed authority that they should not take. But once it's written up in statutes, they assume they watch the statute and go as far as the statutes permit them, and then they go far beyond that, knowing that there are not many people who can amass the kind of legal background, legal wizardry and the funds that would take to correct a problem like this. Let me tell you about someone who would like to see some of the ills of the court system corrected, some of the reforms that need to be in place one of these days, in order that our families might live in peace, that they might once again trust their government, that they might support what their government does. Here is a reformer of great renown in this territory, because he is the judge of the judges. Why does he do that? Because no one else will do the job. So he has accepted the challenge and is ready to plow through to bring about reform here in central Iowa. Terrance Walker.
Thanks a lot, John. You always give me those great accolades. I feel like it's going to be hard to live up to whatever you're actually billing me up to be. But appreciate it though. Appreciate it. And I think there's, all of this stuff that we hear happening. It stems from the lack of accountability, and there's not enough safeguards in place to make people accountable or to at least protect the average citizen from these type of abuses taking place. And so what we have here is a system that's sort of out of whack, and that pertains to not only the DHS and the Child Protective Services, but also the judiciary and the justice system, which I always talk about. Um, and when we talk about accountability, I mean that's it's like excuse me, I want to make sure that I'm heard here. It's kind of like going to a football game. I know there's a lot of Iowa Hawkeye football fans out there, and a lot of football fans in general out there. Now, how would you like it if you went to go see your favorite football team play a game, and they're supposed to have all these rules, and they're supposed to have officials? Well, what if the officials just turned a blind eye on all or part of the game? Now, wouldn't you be offended, especially if they happen to negatively impact your favorite team? If you was a Hawkeye fan or a Cyclone fan, or if you was even a Chicago Bears aren't in it this year. If you was a New England Patriot fan and you went to the game and the ref did not, the umpires, the officials, they didn't call anything, and happened to make your team lose. Now, wouldn't you be mad? And that's how we should be. If we're in the United States of America and we go into the courts, and the courts and the judges start turning a blind eye to some or all of the rules when you go into the courtroom, and you know not many of us have experienced this. I mean, I know that not everybody goes to court. I mean, you know, some people have went on traffic tickets and some minor things, and some have served jury duties, but the vast majority of Americans, I don't think, have seen or witnessed a great deal of court cases or courtroom proceedings. But when you go and you experience how things are actually ran and see how things go in the courts, I mean, I guarantee you'll be like that mad fan that's at that game where the referee or the umpire or the official just did not missed all or half of the calls, and your team end up losing. Well, that's what's happening here in America. That's why we need accountability, and that's why we need this show, because this is one form of accountability, because we're putting a light to the situation, and I think that's a good thing. But there's a lot of people, a lot of organizations that are fed up with the way that things are going in the courts, and they're actually pushing for accountability. And there's one organization in Kansas. There's an organization called the Kansas Judicial Review of Johnson County. Uh, this comes from the Topeka Capital Journal editorial board. And this group, the Kansas Judicial Review of Johnson County, announced it had conducted a successful petition drive to force a ballot measure next November calling for judicial elections. The group says judges should be more accountable to the public for their rulings. The way the system is right now leaves people in the dark, said Tim Golba of Lenexa, who led the petition drive, in a story distributed by the Associated Press. If we are a government of the people, by the people, for the people, then I think the people ought to have a say-so in that part of a government. And some Shawnee County residents might be nodding their head in agreement with that sentiment for good reason. Time hasn't dulled the outrage over lenient rulings last year in several cases involving sex offenders. One of the most infuriating examples was the Shawnee County District Judge Matthew Dodd's decision to grant probation to a 38-year-old man convicted of 17 counts of raping and sodomizing a 14-year-old girl. No doubt, many residents would have voted to replace Dodd if given the chance. But those inclined to follow the lead of Goebbels' group should be careful what they wish for. And I don't follow that sentiment. I think that elections are a good thing. I know that some in the editorial boards and some of the papers across the nation, they tend to follow the belief that elections in judicial areas are not good. Well, in some instances such as this case and the cases in Iowa, where the judges are basically appointed by a nominating commission, I think that leaves the average citizenry out of the loop as far as the process is concerned. Now, one good thing I could say for Kansas is that there's a Kansas Commission on Judicial Performance. What they're trying to do is they're trying to come up with a new process for evaluating judges. And then under that process, people who directly observe a judge would fill out questionnaires about that judge's performance. However, those evaluating judges would include law enforcement officers, court workers, and attorneys. It doesn't necessarily say that it would be the average citizen. So again, it's leaving average citizens out of the loop. And average citizens are the people that are the most greatly impacted by the judicial system. Now, another group calling for change, the Wisconsin Democracy Campaign, they want to reform how judges are disciplined. Now, their call comes after a study done by the Democracy Campaign showed that a large disparity existed between how Wisconsin's legal professionals are disciplined. The group looked at disciplinary actions over the last 6 years against attorneys and found that many of their licenses have been suspended for offenses as simple as not paying state bar dues on time or meeting continuing education requirements. WDC Executive Director Mike McCabe says that that's compared to cases such as Justice Annette Ziegler's, who faces a reprimand for judicial misconduct. The disciplinary process for judges and lawyers begins in different areas, but McCabe says it's the Supreme Court that decides how misconduct is handled, and McCabe says the High Court needs to hold judges to a higher standard of accountability. And it's sort of like the foxes guard the hen houses, because when the judiciary is the one setting the standard and setting the mode of penalty and the standard of penalties in these cases, and it's no wonder that the judges are given more lenient reprimands and penalties compared to lawyers, and that's true as here in Iowa. I mean, you can go right to the judicial website for the Iowa Supreme Court, and you can just glean a few cases off of there on how the attorneys are disciplined as it compares to some of the judges that have been disciplined. Now, you might not find that there's been too many judges that have been disciplined, but the few that you will find that have been disciplined, their discipline is way extremely lighter than a lot of the cases in which you see the attorneys. The attorneys are suspended for years. I don't know how they're supposed to earn their income. Maybe they do paralegal work, or maybe that's even banned in some of the cases. But you don't see that too often in a case where there's a judge involved. They might get a reprimand, they might get a public censure, and that's about it. Don't see too many cases where they're actually removed and thrown off the bench. There's been like a handful of those in the past couple dozen years or so. Would you say, John?
That's right.
And then one other side note. Do you have something else to say?
No, they're certainly not anywhere near the number of judges being dismissed as the number of judges who perform acts or who should be dismissed. In other words, I think the percentage would be pretty low if we managed to get all of them dismissed who foul up. I think it would be quite amazing, would it not? Or even a fair percentage of those.
They could just get 1%. That would be commendable.
Oh,
I don't even think they could get that. I mean, it's just
The
they go through hundreds of complaints every year, and they have one or two maybe that they do a public censure of, maybe.
The thing of it is, I think that once you started on a project like that, the word would get around very fast. And you might find some judges cleaning up their act in a hurry so that they don't get caught.
Yeah, and I think that would be a positive thing as it pertains to
Sure.
the citizenry. Um, one guy that we've had on the show, um, it's been about a year and a half ago, 2 years ago. His name is Ron Branson. Now, this guy is probably one of the most, I would say, he's probably in recent years, he's probably pressed the hardest for judicial accountability here in the nation. Now, this guy, very active in as it pertains to judicial accountability. He started an organization such as called Jail for Judges, JAIL, Judicial Accountability Initiative Law, and the Judicial Accountability Initiative Law has several missions. It's basically to create a forum in which to hold judges accountable to the people under constitutional standards, to stop the abuse of judicial immunity by the judiciary, to provide a remedy that will ensure the people of the availability of redress of grievances in our court, to be autonomous and independent of government, to not change laws on the books or the judicial system as currently structured, to act only when the judicial system has failed in its constitutional responsibilities, and to achieve its mission through nonviolent means. And you can see a copy of this mission statement on the Jail for Judges website at JAIL, the number 4, judges.org. And you can see some of the things that they've done in the past several years. One of the things that they've most commendable that they've done is they set up state chapters across the country, and various legislatures, their organizations have been pushing this legislation through each one of their state legislatures and trying to get it implemented. One attempt failed, I guess, about a year and a half ago in South Dakota, unfortunately, and there's been some allegations of voter fraud as it pertains to how the initiative was basically drawn up and explained on the ballots. That is explained on that website. But I wanted to bring Ron Branson to everybody's attention for the simple fact that he got injured here a couple weeks ago. I guess after Christmas he was putting up a ladder and got, tried to get some tangerines out of the tree and ended up falling and ended up fracturing some bones in his not only in his back but also in his ribs. So he's been kind of incapacitated for a couple weeks and probably incapacitated for a few more weeks as it seems. But I did wanted to give a shout out to him and hope he gets well, and hopefully everybody out there sends him you can get on the website and email him and pray for him. Hopefully he gets well because he's doing a good thing. And that's all I had to say for this week.
Okay, well, thank you for those remarks pursuant to the reform of our Iowa courts. Without those courts, we cannot continue to have peaceable lives, conduct our business, and maintain a good, lively state unless we do have the cooperation of what they call the judicial branch of government. We're going to be talking one of the issues here, if we have time, about where the judicial branch wants to become a part of the legislative branch. That is, they want to recommend laws which give them more authority to do things. Isn't it strange that that this seems to be a never-ending battle? And it would be good if our branches of government would respect the authority and practice and boundaries of the other branches, wouldn't it? Well, apparently some of these people think they can step from one branch of government to another branch of government with no problem. Well, Don and I are going to present the final um, recommendations of the homeschool legal defense. We've been doing this the last 2 weeks, and it's quite a job because there's over 60 of those recommendations that are up before the public. And these are recommendations that appear from based upon my background and knowledge of the system that seem to be fairly reasonable recommendations. I'm going to read number 54 because Don advises me that we've already covered 53 of the recommendations. 54 says, make the true and actual numbers of children in foster care or other state custody arrangements publicly available annually. That would be good to know just how many of those children government has in custody, along with the true and actual numbers of reported cases of abuse against children in state custody, and the true and actual numbers of deaths, including accidental and intentional suicides of children while in state custody, and the true and actual numbers of state custodians and caretakers prosecuted for these abuses. That calls on government to become something that you mentioned here a moment ago, Terrance, accountable. In other words, give us the numbers of these cases that you're actually working with, and that may help a whole lot to know what is going on here. Number 55, Don.
Require that the states protect the rights of the accused by allowing them to face their accusers, even if they are children in court. For many, many years anyway, the accusers could not face, or the accused could not face the accusers. So it was harder for the accused to get what do you call it? Get rights in court.
Yes. Even now, Sixth Amendment rights aren't taken seriously in DHS cases. I worked on one for 14 years, and we finally got the court to admit that even though the DHS didn't have any particular desire to grant Sixth Amendment rights, being able to cross-examine an accused person was sufficiently important to call it an issue. And the law requires that all issues be opened up for discussion in an evidentiary hearing. So at least we won that particular point, that you can't skip an issue simply because a person might be embarrassed by having to testify. Well, number 56, require that a child may refuse medical treatment or examinations without his parents' representative present. By the way, that should be automatic. In other words, it should be the parents granting the permission rather than to assume that they have the permission unless the child somehow raises an objection.
You left out one word there, John. You better repeat the sentence.
Okay, require that a child may refuse medical treatment and or examinations without his parents, parent or parents representative present. The child must be informed of this right prior to any examination or treatment, and said statement must be videotaped, and the accuracy and completeness of said statement sworn to under the penalty of perjury. Not a bad idea. Don?
Tell a 3-year-old child his parent has rights.
Yeah, right.
Or a 5-year-old child, or 10-year-old child. I don't know when they start learning the legal rights that they have in school. I didn't know them until uh, I probably hit 50 years old, that you do have rights, but they make you think you don't. Number 57, require that a child may refuse to speak to anyone without his parent or his parent's representative present. The child must be informed of this right prior to any interview, and said statement must be videotaped, and the accuracy and completeness of said taped statement sworn to under the penalty of perjury. So a child can keep their mouth shut. They don't have to talk about anything. They may be totally innocent. The parents may be totally innocent. But when you talk, the DHS can use your words against you. John?
They sure can, and that's unfortunate. And I don't know how they're going to require that all up and down the line. And some kids have every intention of speaking out when where the parent should have the say, even if the child wants to speak. The parent should have the last say as to whether that child does indeed speak. In other words, his utterances should be totally under the control of the parent. Number 58, require that before the state can order a child into therapy or put the child on any drugs or give the child medical treatment against the parent's will, that the state have a clear and convincing evidence of abuse or neglect against a parent, and that the treatment or examinations are conducted by independent providers, and that the state meets the burden of proof that failure to provide the child with the requested examinations and treatment will seriously injure the health or life of the child, and that the parents may present a case in court against allowing any such treatments or therapies based on the treatment's validity and the validity of the diagnosis, and the instance in which and where there is a need for such examinations or treatment is precipitated by the removal of the child from his family, and the symptoms can be alleviated by reunification, and allow the parents to demand that the child see the medical professionals of their own choosing, and allow the provision for the administration of emergency medical treatment for injuries and acute illnesses for children legally in state custody without parents' immediate consent. Now that I'd have to go back and study that one over phrase by phrase, but you can tell that HSLDA attorneys have spent a considerable amount of time in assembling these recommendations, and I think it behooves someone in our state to look after them and to see if these things can and should be implemented here in the state of Iowa. Don?
One sentence you read, it says, to allow the parents to demand that their children see the medical professionals of their own choosing. The way it is set up now, the DHS picks the professional, and they know that professional. That professional has done counseling or other work for the DHS, and the counselor lines up with the DHS desires, and so therefore the parent usually ends up becoming the loser, losing their children, because the DHS chooses that counselor. 59. Require that all hearings involving the parent or the child, both the parent and child, must be allowed to be present if they so desire, and make it illegal to order either one from the courtroom for anything less than threatening behavior. I mean, yeah, what they're saying is the children, their lives are at issue here, and they should be allowed to be in the courtroom to hear what's going on too. And make it illegal to order, let's go on, and require judges to make every attempt to make it possible for all parties to remain in the courtroom during the hearing. John?
Okay. By the way, that doesn't deviate a whole lot from an initiative set by the Iowa Supreme Court judge, the chief judge, Marcia Terrance, who says that every child, particularly ages 8 and over, should be in every hearing that concerns the welfare of that child. So many of these children are kept in total secrecy and darkness about this whole thing, or even worse, to have the recounting of what happened in court interpreted by a foster parent or someone else who's guarding over the child, give it to them in their with their interpretation. That is a sad thing. The children should be able to hear it firsthand. 60, and we're coming pretty close to the end of this lengthy list of recommendations that I think have certainly been put together in such a way as to command our attention, and I think it should command the attention of individuals who are serving in the Iowa State General Assembly. Require the judge allow the child to speak to the judge in chambers if the child desires, and make it punishable offense if any social worker, guardian ad litem, or other child protection worker conceals the child's request from the judge. In other words, if the child speaks up that he or she wants to speak to the judge, that information should never be concealed from the judge. Number 61, Don.
Require the states to diligently protect the rights of families who are involved with the CPS agencies, or DHS, and that failure to protect their rights as defined above against illegal activities by the state is DHS in this case, will result in the denial of federal funds to the state for the following year in the amount of 25% of the current year's allocation for the first offense, 50% for the second offense, and 100% for subsequent offense. And that said denials of federal funds are cumulative and can be carried forward into subsequent years. Well, that's a good thought. To me, we would be better off if the state didn't accept any federal funds, because by the time the money comes out of the taxpayer's pocket and goes to the federal government and comes back down to allegedly helping you, you lose a lot of money from your pocketbook, and the end result, you lose your children. John?
Greatly discounted, isn't it, by the time it goes to Washington, D.C., and then comes back and tries to help families. In this great nation, we the people are the government. We are holding all of our elected officials accountable for these devastating and immoral violations of our rights and to the rights of our children. We declare the family by its very nature as an institution that predates any government whose sovereign rights are fundamentally inherent to be inviolate to government intrusion. We will no longer let the agencies of government meekly into our homes seize our children. We will no longer cooperate with CPS agencies who lack the experience and the authority and the moral character to judge us as parents. We stand resolute in our innocence and demand that these agencies obey the law of the land in all of their doings. Well, so says the Homeschool Legal Defense Association, called HSLDA, and you can get more information about these initiatives of the Homeschool Legal Defense by contacting parents rights dot let's see, is it .gov? No, it's not.
Org?
It's .org. parentsrights.org. And you can sign a petition that will assist that organization in getting it written into the United States Constitution as an amendment to thoroughly protect the rights of parents. who have this God-given right to guard over the care and custody of their children. Well, a couple of things I need to note here. Our General Assembly is gathering together right now, and the one organization that has the most to do with matters of the Department of Human Services called the Human Resources Committee. It's a standing committee, and there are 100 of the 100 state representatives. A few of them serve on the Human Resources Committee. Mark Smith is the chairman of that committee in the House. Akeo Abdul Samad, Polly Granzo. Akeo is a Democratic sidekick, and then Polly Granzo is the minority member of that committee. Ro Fogey, Wayne Ford, Greg Forrestal, and there's quite a number of individuals on that committee. I was looking at not only at the committees, there's one of these committees also in the Senate, and I noticed that some of the initiatives that they're attempting to put across are both being initiated in the House and the Senate. One of those initiatives, by the way, I looked at some of the study committees that are involved here, and one of the study committees, these are called House study bills, is a study bill that requiring children to have dental screening as a condition of enrollment in elementary or high school and providing effective date. Another one is called a study bill relating to the child in need of assistance proceedings and appeals in juvenile court. This one struck me as somewhat strange in that it is asking the state legislature, that is the Iowa Supreme Court, is intervening here and asking the state legislature to look at some things regarding child in need of assistance. In this particular case, they want to make a new category of children in need of assistance in House Study Bill 23. This bill relates to child in need of assistance proceedings and appeals in juvenile court. The bill modifies the definition of China in juvenile court to include a child who has a serious mental illness, a disorder or emotional damage, and whose parents are unable to provide treatment. What it does, it provides a shortcut so that they don't have to go through all of the proceedings that other China cases have to go through, and they're going to write the rules so that they can effectively take care of all of the problems of subsequent appeals from any lower court decision, and no lower court decision has to be final before the Iowa Supreme Court rules on the case. Rather a strange arrangement, backdoor arrangement, and I'd have to look into this case a little bit further to understand just precisely what is intended here. It doesn't look like a real good measure for us to support. Well, thank you for dropping by the CPI report. We'll see you next week.